some little difficulty about some, so I had to go to the polyclinic. So
Yes, my lord. Your lordship.
So sorry to keep you.
When your lordship climbed, my lord, it.
So sorry to keep you waiting.
I hope, my lord, nothing.
Yeah, no, it's okay. Thanks so much. But sorry to keep all of you waiting. It was because of me really that you were all held up.
Okay, I'm glad.
Sorry, Mr.
So, Manoj, I was on the list of dates. Let me finish that first. So I was on item 47, Manoj.
Yes.
Now 48. As the delinquent MLAs of SSLP voted against the party whip on 2nd of July issued regarding the election of the office of the Speaker, fresh disqualification proceedings were initiated against the delinquent MLAs as per the provisions of 21B of the 10th schedule. Because they voted against the party whip, so all 39 were involved there. So 16 earlier, then on the 27th, the balance 22, for which notice has not yet been issued, and all 39 now. Because this is 21B, that's 21A. And even for this, notice has not been issued.
So this 3rd July was issued against how many you say?
39.
39.
Under 21B.
21B.
For violating the whip. And 21A, I'm sorry?
Fresh one.
Fresh one. 21A, 16 earlier, for which notice was issued, and 22 later, for which petition was filed, but then, of course, next day was the trust vote. I mean, there was a decision, and therefore no notice has been issued here. Even now, no notice has been issued. So those are all pending.
And now the 39.
Now the 39.
The Speaker.
That's correct. So, and the election of the Speaker was held in complete violation of the provisions. Certain MLAs submitted a letter notice to the Principal Secretary Maharashtra to move a resolution for removal of Rahul Narvekar from the office of Speaker under 179. This is the tit for tat bullets. This is not an argument that I wish to make, bullets. On 3rd of July 2022, just after being elected as the Speaker of the House, Narvekar entered the political thicket and issued a communication late in the evening on 3rd of July, illegally recognizing Bharat Gogavale as the chief whip and Eknath Shinde as the leader of the party. On how basis did he do that, Maharaj? This is under challenge. Under which power did the Speaker do that? Your Lordship knows, Maharaj, this has to come from the political party. Leader of the House has to come from the political party he is our leader of the House, Maharaj. That letter is written by the Speaker, Maharaj. For example, Maharaj, recently, when Mr. Kharge became the leader of the Congress party, it is Mrs. Gandhi who wrote a letter saying that now, instead of Ghulam Nabi Azad, Mr. Kharge is the leader of the party. I have the letter with me. So on what basis did the Speaker do it? The aforesaid communication of the Speaker of 3rd July was challenged by Sunil Prabhu before this Honorable Court, wherein the Honorable Court, by order dated 4/7 in writ petition, directed to list the writ petition along with other connected writ petitions. So that's also pending. Then 4/7, as the Speaker has misconducted himself by entering into the political thicket and attempted to recognize Bharat Gogavale as the chief whip of the Shivsena, certain MLAs submitted a notice to the Principal Secretary Maharashtra Legislative Assembly to move a resolution for removal of Narvekar from the office. Then, on 4/7, the confidence motion was called for on the floor of the Maharashtra Legislative Assembly by Eknath Shinde on 4th of July. Confidence motion was carried out in favor of Eknath Shinde. Again, several MLAs of the Shivsena voted contrary to the whip issued by the official chief whip of the Shivsena. 4/7/2022, Bharat Gogavale, and when your lordships will see the petition before the Election Commission, till the 18th of July, there is no reference to any meeting of any political party. So all this was happening outside the political party. Bharat Gogavale also filed disqualification petitions against 14 MLAs under the 10th schedule for the alleged breach of the whip issued by him. it is submitted that Bharat Gogavle has not been authorized by Shivsena political party to issue whips on behalf of the Shivsena. 5/7/2022, since the delinquent MLAs of the SSLP has openly defied the whip dated 2/7/2022 in the floor test, confidence motion held on 4/7, Sunil Prabhu has filed fresh disqualification petitions against 39 delinquent MLAs seeking their disqualification under 2(1)(b). Then 7/7/2022, Uddhav Thackeray, in his capacity as president of Shiv Sena, wrote a letter to the speaker objecting to the illegal recognition of Bharat Gogavle as the whip of the Shiv Sena and reiterated the decision of the Shiv Sena political party to recognize Sunil Prabhu as the whip of the SSLP. So, Malas, what's happening here is, Malas, that the legislative party, a majority in the legislature of the Maharashtra Legislative Assembly, is treating itself as the political party and making orders for its own benefit. That's the constitutional issue that your lordships will have to decide.
But who represents the political party is
as I said, Malas, the two offices, Malas, that is the leader of the three offices, chief whip and whip, are appointed by the political party and conveyed to the speaker.
The chief whip
and the deputy whip.
The deputy whip.
So these are offices, Malas, that are bridge between the political party and the legislative
and then
party.
According to you, who determines who is the political party?
I'm sorry?
Who determines who is the political
There's no
party?
challenge here.
No, I mean, ultimately, who is entrusted with the authority to decide?
They have to have a split in the party first. Otherwise, how do you determine under the 10th schedule?
If there is a contest on who represents the political party, who will decide?
There's no contest, Malas. This is not their case. Malas, please appreciate. Till all this is happening, it is not their case that there is a political split in the political party. It is nobody's case.
No, but
They say they are the Shiv Sena.
Facts here, but who will then have the authority to decide who is the political party?
That's right. Now you go, what you do is call a meeting of the political party. Supposing, Malas, let's forget about the 10th schedule. Let's not talk of the 10th schedule. Malas, I happen to be a faction in the party, and I say, look, actually the majority of the party is with me. So like in requisition a meeting of the party, forget the 10th schedule. And Malas, after a requisition of meeting of the party, Malas, I take over. So I am the party. By majority, I take over.
Against you.
And there's nothing to do with the 10th schedule. I'm not talking about the 10th. I'm sorry.
Test as they have said.
Sorry.
The test in Sadiq Ali.
Test in Sadiq Ali is nothing to do with this issue, Malas. That's not. I'm not talking of the 10th schedule now. I'm talking generally how a faction in a party can take over the party. Forget the 10th schedule. Now, let's forget that 1985 10th schedule was not there. Then also this question would arise. But this question would arise only if there is a division in the legislative party. Dehors the 10th schedule. I hope, Malas, I made myself clear. Dehors the 10th schedule, this question can arise. That people in the legislative party can say that, look, no, we don't agree with your policies. Let's call a meeting of the party. Right? In that meeting, Malas, they feel that they are a faction who are entitled, Malas, to the symbol of the party. They want to set up a separate party. Right? They can go and say that we, the legislators, along with the organizational structure, are the party, separate party. Give us the symbol. We are the majority. Forget the 10th schedule. It can happen even out, but that can only happen if there's a split in the legislative party. Correct, Malas? It can only happen then. Otherwise, it's a normal procedure of taking over the presidentship of the party. Sadiq Ali, the same thing happened. There was a split in the legislative party and the political party. And in Sadiq Ali, they said that, look, as far as the organizational structure is concerned, on both issues, they are entitled to, the other side is entitled to the symbol. That's fine, no issue. Here, Malas, this split should have happened on the 21st of June. There's nobody's case in the political party. Why? Because para 15 of the 10th schedule says that if there are two factions, And the symbols order says, if there are two factions resulting from a split in the political party, then the question of symbol will arise. Right, Manoj? It is nobody's case here. Nobody has, they say they are the Shivsena. Why? Because they are 40. So how does a majority on the legislative assembly become the Shivsena? Then, Malaj, if in the Congress in Goa, if majority of the Congress legislators join, as they do, Malaj, I have been seeing this happen again and again, Malaj, then they are the Congress. They can say they are the Congress. But how can they say that? Therefore, Malaj, this has grave consequences on the polity of this country. Because now the legislative party seems to believe that it can, under the 10th schedule, proclaim itself to be the political party and throw out office bearers who are appointed by the political party in the House. Constitutionally, that cannot be countenanced. Who appoints the leader of the House? Says, in exercise of my power as chairperson of the Congress Parliamentary Party, I hereby make the following appointment to the Rajya Sabha. Shri Kharge, MP leader of the Congress Party, against the vacancy of Ghulam Nabi Azad, whose term in the Rajya Sabha has come to an end on 15th February. This is a letter written by the Congress UPA chairperson to the Speaker, to the chairman of the Congress or the Rajya Sabha. That's how Malaz people are appointed. Can Malaj, Mr. Kharge on his own, or could he have said that I am the leader? I have so many MPs, so I am the leader? The same thing with the whip. Now, Malaj 57. The newly elected speaker in an illegal, arbitrary, and blatant display of malafide. And how do you, Malaj, allow this speaker to decide this matter when he's been doing these things? Your Lordship, Malaj, has great, what should I say, confidence in the constitutional office of the speaker, Malaj. Great confidence. But do they discharge this confidence?
But that confidence you also have when you say that that speaker had to decide a disqualification petition.
Yes, correct,
And
Mother.
that is not
It will be
dependent
subject
on
to challenge. It's subject to challenge.
Right, and that is not dependent on who is the speaker, Mr. Sivan.
No, Malaj, I'm sorry. That speaker did not do anything like this, Malaj. You have to now see, kindly see, look what is happening.
But the constitutional authority of the speaker to decide is not based on who the speaker is, on what decisions he is
Malaj,
taking.
can ever a finding of bias be reached by a constitutional court? You lordships will say no. Let's put it another constitutional issue. If a constitutional authority has so conducted itself that a constitutional court comes to the conclusion that such a constitutional authority cannot discharge the functions that it is discharging because of its open bias, your lordships will say no, we let them decide. I don't know, Malaj. I don't have the answer for it.
No, not necessarily. In Rameshwar Prasad, with respect to a governor,
Governor, yes.
judgment of this court that if there is an allegation of bias, then government has to come and defend it.
Malaj, that's exactly.
It's possible, not that the court will naturally do it, but then we all are proceeding on the premise that, in fact, your argument had been in the first part also, that so far as the speaker is concerned, it's a constitutional authority.
No, but see what he has done. He has appointed the whip. He has appointed the leader of the house. What kind of confidence can we have in this constitutional authority? Who, without reference to the political party, is doing all this? Do you think he can ever decide in my favor? There is no way.
But then you have the first speaker who,
That's-
in defiance of the legislative rules, gives 2 days notice.
I'm sorry. No, that is.
In defiance of the
Malaj,
legislative rules,
Malaj,
gives
Malaj,
2 days notice. What is also
That your lordship,
Yeah, all this is the way everybody is behaving.
and that's correct. So what do we do, Malaj? Your lordship will then have to.
So there are two options.
Asking some.
Either you debunk the authority of the speaker, Or you say,
I said that
irrespective
on,
of what,
I said that on day one,
I
Malad.
think at that-
alternately, irrespective of what lesser mortals decide, ultimately, in a democracy, you value the office or the institution.
Then that 27th order should not,
If we say.
correct, then the
start-
27th order should not have been passed.
Denigrating constitutional officers, including the office of a speaker.
Malad, they are
then there's
denigrating
no end.
themselves.
It's a,
They are denigrating themselves. We are not denigrating
No,
anybody.
Mr. Sibal, there's some problem.
it's a race to the bottom then.
Yes, we have. We have to start Mulad's what to do. But the problem is, Malad, that problem is very serious. And therefore,
It is they are the legislators, parliamentarians who have decided upon the speaker to be the tribunal for 10th schedule. It is parliamentarians' decision.
I agree.
Then
Malad.
schedule. So therefore, court is only interpreting that.
Fine, Malad. Then we must go back to
But this doesn't
27th.
take us anywhere, Mr. Sibal. The difficulty, repeatedly you say, at one stage, it poses a very big problem for the court.
Yes.
On the one hand, if the speaker is with you, you would say that it's a constitutional authority. What's wrong with the speaker? If you have some difficulty, you would say, you means not you. You would say, look at the way the speakers have behaved. So therefore, for us, as long as the Constitution bench judgment is there, we will go by the fact
I
that
agree.
the speaker is the tribunal and he is the presiding officer for 10th schedule.
Correct.
And
Correct,
we will not go back the decision. That's the final decision so far as we are concerned.
Fine. That's, I mean, I don't,
proceed.
I don't want to, Malad, say anything contrary to that, except that on that logic, the 27th order could not have been passed.
You will argue that.
Then we come back to that. Malad. And that's what led to where we are today.
And again, it's merely because one or two speakers have gone astray, would the court be inclined to debunk the whole procedure as laid down and the 10th schedule?
No,
by
no,
saying-
Malad, I mean, my intention is not that. I'm just, Malad, telling your lordships what has been happening.
So it's a conundrum.
Yes, it's a conundrum. It's a constitutional conundrum, but your lordships will one day have to sort it out.
Sorry for another question. Every time this question is raised before the court, I would want to ask you, how many times did the parliamentarians raise this question in the parliament saying that let us actually amend the constitution, change the speaker? How many times the discussion took place in the parliament to review the conduct of the speaker?
Well,
Why is that question raised before the court, which is not the forum for consideration? How many times the parties have sat down together and decided that this is not working? Let us go back.
Once the Kyoto Holohan was rendered, Malad, what would Parliament would say?
Why it only upheld the 10th schedule. It is you making the 10th schedule.
No, Malad, the political party in power, wherever it is, wants to use the office of the speaker to do what they are doing. The political party would never, in power, would never like to change it.
This will take us nowhere, Mr. Sibal, frankly, and this will, unless there's an amendment to the constitution, unless there is a reference, a direct challenge.
Malad,
And so
Justice Sabharwal
we
said
have
it.
to
Malad.
proceed on that premise.
Justice Sabharwal said it in a judgment of this court, Jagjeet Singh. Exactly that. Undoubtedly, our constitutional scheme, the speaker enjoys a pivotal position. The position of the speaker is and has been held by people of outstanding ability and impartiality, without meaning any disrespect for any particular speaker in the country, but only going by some of the events of the recent past.
Constitutional entrustment of power.
Recent past. Certain questions have been raised about the confidence in the matter of impartiality on some issues having political overtones, which are decided by the speaker in his capacity as a tribunal. It has been urged that if not checked, it may ultimately affect the high office of the speaker. Our attention has been drawn to the recommendations made by the National Commission to review the working of the Constitution, recommending that the power to decide on the question as to disqualification on the ground of defection should vest in the Election Commission. I dread that as of today, Malad. Election Commission instead of the Speaker of the House. Concerned, our attention has also been drawn to the views of a number of other experts, committees, commissioners, to the effect that power of disqualification as a result of defection needs to be exercised in accordance with the opinion of the Commission, as in the case of decision on questions as to disqualification of members. Whether to vest such power on the Speaker or Election Commission or other institution is not for us to decide, as your Lordship rightly said. It is for Parliament to decide.
Exactly.
Right, I agree. I'm not disputing
be
that. But I'm just saying the disquiet that we have witnessed in the functioning of the office, that's all that I'm saying. I'm not saying this person is good or that person is good. It's the institutional framework within which he functions, Malad, is not consistent with his responsibilities as a tribunal. That's all that I'm saying. What to do? But the fact is that he had no authority in law to decide on the whip and on the leader of the House. That's not his.
That's a separate issue. We made a note of that.
That's why I make that argument. Then let's come to the newly elected speaker in an illegal, arbitrary, and a blatant display of malafide and bias issued notice to 14 MLAs seeking their response to disqualification petitions filed by Bharat Gogavle. The speaker is still sitting tight on the disqualification petitions filed by Sunil Prabhu and has not even issued notice in them despite their disqualification petitions being filed much earlier. He issues notice on their disqualification petition, but not on ours. And they haven't filed a reply, Malad. This court said in the interim, we adjourn it to 12th of July. Malad, from July, we are in February. Where's the reply? "18th of July, the notice issued by the Speaker in the disqualification petitions filed by Bharat Gogavle against 14 Shivsena MLAs, including Sunil Prabhu, was challenged by Sunil Prabhu in writ petition, wherein this Honorable Court, by order dated that, directed to tag the writ petition along with other connected matters." So that's also before your Lordships. And now, Malad, the Election Commission says they are the Shivsena. Now we'll be further disqualified. Any meeting called, if we don't attend, then when we are, Malad, then it'll be further problems. Despite the fact that this Honorable Court is seized of the issues regarding disqualification of Eknath Shinde under the 10th schedule, Shinde filed a petition before the Election Commission under para 15 of the election symbols reservation and allotment order to declare the splinter group led by him as the Shiv Sena. So this is the first time, Malas, that he went. On 20th July, by order dated 20th July, another in writ petition so-and-so, another connected petition, this court issued notice in writ petition so-and-so. It was directed by this Honorable Court, the writ petition shall be treated as the lead matter. 20th July, pursuant to the order of the court dated 20th July, Shri Subhash Desai made a representation to the ECI, by representation requesting ECI to not proceed with any petition related to Shiv Sena, as substantially similar matters and issues are pending before this Honorable Court, and not to take any preemptive action. Then IA 100285 was filed on 21st July, was preferred by Sunil Prabhu in writ petition seeking direction to the Speaker Maharashtra Assembly to produce the following records. All proceedings relating to disqualification of rebel Shiv Sena MLAs filed by Sunil Prabhu. All proceedings related to disqualification filed by Shri Gogavle. All proceedings of the Speaker and Deputy Speaker in relation to recognition of the Leader of the House and Chief Whip of Shiv Sena. Proceedings of the House on 3rd July and 4th July. 22nd July, without deference to the proceedings pending before this court, as well as without considering that no adjudication can take place till disqualification petitions pending against delinquent MLAs are decided, Election Commission issued notice to Uddhav Thackeray on the petition filed by Eknath Shinde. And on 25th July, agreed by the issuance of the notice by the Election Commission, in Shinde's petition, Subhash Desai was filed 2 applications, IA so-and-so, seeking impleadment of Election Commission of India as respondent 51 and writ petition so-and-so, and seeking stay of proceedings initiated by the Commission on 22/7 till the final adjudication of the present petition. On 4th of August, this court, after hearing the Election Commission and the parties, recorded the submission of the Commission that no orders may need to be passed by this court interdicting proceedings before the Election Commission. Liberty was granted to the petitioner to file an application before the Election Commission for seeking time. Accordingly, 6th August, petitioner in terms of the order of 4th August filed an application with a prayer to defer adjourn the proceedings in dispute on dispute number 1 of 2022 for 4 weeks and extend the time for filing a response for 4 weeks. 10th August, Election Commission communicated to the petitioner extending time. 23rd August, Honorable Court, by its order, held that the present batch of petitions raise important. Then those questions were, then your Lordship straight come to 23rd August. made a request on the very same day to the commission to defer proceedings. Then this went on, Malats, and on 22nd of September, a further request was made by the petitioner to the commission for deferment of proceedings by 2 weeks till this court decides the question as to whether proceedings before the commission should go on. And then 27 December, your lordships, Malats, dismissed the application. So that created another problem on us because the election commission decided the matter, dehorsed these pending proceedings, and on the basis of that majority in the legislative assembly has given them the symbol. Well, that very majority is subject of disqualification petition. So we have another problem. And we went to the commission and said, please await the decision. The Supreme Court did not stay. It didn't stay the proceedings, but the Supreme Court did not say that you decide it on merits based on majority in the Legislative Assembly, because those disqualification petitions are pending. But he said, no, Supreme Court has said no stay, so I will decide the entire matter. That's the other problem that happened. Because I never thought your lordships meant stay of proceedings only meant that you decide whatever the matter is, you hear the arguments, decide on law, on the submissions made, but they took it. The High Court also took it the same way. We went to the High Court also. They rejected it, saying your lordships have said no stay. Therefore, the commission can decide what it likes. And I told the commission that, look, if supposing you give this symbol to them based on this majority, and ultimately they are disqualified, then what happens to the symbol? Will we get back the symbol? Sumalas, we have another problem on our hands. So anyway, only your lordships can decide this matter. We can only place the facts before you. You have to do something to be able to ensure that there is confidence in institutional frameworks in the system, in this country. That's my only concern. Winning or losing doesn't matter. These are political battles. Will be won today and lost tomorrow, or lost today and won tomorrow. But the institution must go on, and the people of India must have confidence in that institution, whether it's the Election Commission or the Office of the Speaker or the court. Now, then we come to 4th October, Eknath Shinde filed an application before the commission under para 15 of the symbols order to urgently hear, dispose of, and allow the petition filed by Shinde under paragraph 15. On 7th October, Thackeray filed a preliminary reply to the application under para 15 with a prayer requesting commission not to pass any order without an opportunity of oral hearing to Thackeray. Well, on 8th October, Thackeray filed a reply to the application of Shinde under para 18 of the symbols order. Election Commission, without hearing either of the parties. This is another curious thing. On 8th October, without hearing either of the parties, and merely hours after the reply of Uddhav Thackeray was filed, passed an order in dispute 1 of 2022, inter alia freezing the symbol of bow and arrow. And your lordship knows, Mallas, that a hearing is required. It's mandatory under paragraph 15. Also, the Election Commission directed Uddhav Thackeray and Eknath Shinde to first furnish their preferences for interim party names and interim symbols. Uddhav Thackeray, under protest and without prejudice to his right to challenge the impugned order, freezing the symbol bow and arrow, proposed 3 interim names and interim symbols of his own choice in the order of preference. 10th October, Shinde proposed his preferences of symbols, out of which first 2 were identical to the interim symbols proposed by Uddhav Thackeray. The first interim name proposed by Shri Shinde was also identical to the first interim name proposed by Thackeray. On 10th October, Election Commission rejected the first 2 interim symbols proposed by Thackeray on the basis of Shinde had also proposed. Due to some same reason, Shri Uddhav Thackeray was denied the interim name Shivsena Barasaheb Thackeray. On 10th October, agreed by the arbitrary freezing of symbol without affording an opportunity of oral hearing, by order dated that passed by the Commission. In dispute 1 of 22, Uddhav Thackeray filed a writ petition in the High Court of Delhi, seeking inter alia to quash the aforesaid order. Election Commission allotted the interim name Balasaheb Banchi Shivsena to Shri Eknath Shinde and requested Shinde to furnish a fresh preference list of symbols. 11/10, Eknath Shinde submitted a fresh list of preferred symbols. Election Commission allotted the symbol of Do Talware or Ek Dhal to Shri Eknath Shinde. The present batch of matters was listed before the Constitution bench for directions on such and such day. Then Miller's Election Commission addressed a letter to Uddhav Thackeray and Shinde asking to submit all the details, particulars, documents to dispute one. And the High Court of Delhi dismissed the petition filed by Uddhav Thackeray.
Yes.
We'll have
Yes, DB also.
the date of the decision. Yesterday or day before, election commissions?
Now the Election Commission.
Yesterday.
17th of October.
Yesterday, day before.
17th February. So that's Muller's the really list of dates and the list of events. Muller's, having said that, just let's go to the 10th schedule straight away. Muller's.
Yeah.
In this schedule, unless the context otherwise requires, House means
हल्का लगा.
winter mode, Muller's.
Summer has come early.
Yeah. Summer's come very early this year.
Unless the context otherwise requires, House means either House of Parliament or the Legislative Assembly, or as the case may be, either House of the Legislature of a state. Legislature party in relation, just Muller's, just to have the facts straight, Muller's, out of 55, 38 are with them in the Maharashtra Legislative Assembly, right, Muller's? And in the Lok Sabha, out of 18, they allege that 13 are with them, but they have filed affidavits of 12. The Legislative Council, Muller's, in Maharashtra, all of them are with us. All 12 are with us.
12 out of 12.
All of them are with us. And in the Rajya Sabha, 3 are with us. And in Lok Sabha, 6 are with us, according to us.
Mr. Sibal, will you repeat the numbers?
Yes. In the Legislative Council in Maharashtra, all 12 are with us.
1 second.
All 12 are with us. But in the Legislative Assembly, Muller's, 38 are with them. You say 40, but they have affidavit of 38. It's all right. I mean, you can say 40. I don't mind. I mean, yeah, it's all right. 40 and 15 with us. Doesn't matter. In the Rajya Sabha, all 3 are with us. And in the Lok Sabha, whereas out of 18, they are 19. 13 are with them and 6 are with us. So it's not as if, Muller's, it is some overwhelming majority with them. And in the organizational structure, and what is...
What about the Rajya Sabha? you said?
Lok Sabha
Oh, three Rajya Sabha are all with us.
and Lok Sabha.
Legislative, Lok Sabha, Muller's, 6 are with us out of 19. Yeah, out of 18. So in 2 houses, they have majority. In 2 houses, we have majority. But be that as it may, Muller's, the issue is ultimately not that. But just so that your lordship knows, Muller's, in the organizational structure, the other surprising thing is, Muller's, we both argued on the Constitution of 2018.
What is the organization?
On
What is
the
the
Prathinidhi
structure of
Sabha,
organization of
there is a
Shivsena?
Prathinidhi Sabha and there is the Karyakarani, which is the executive, largest executive body, 13 members of the Karyakarani, and
General
about
body is
260 odd members of the Prathinidhi Sabha, which will come to later. The point that I'm making is that we both relied upon the 2018 Constitution, but the Commission in its order, without letting us know during the argument, said that the 2018 Constitution is not recorded in the Election Commission. Never put it to us, never told us, not their argument, not my argument. both argued on the 2018 Constitution, and the Commission, without ever informing us, says that Constitution is not on our record. Anyway, but that is it. Anyway, so even though we have majority in the organization, they say we will not consider that. So they don't consider the organization, they consider this majority of those who are, according to us, disqualified, and give them the symbol. So you move from the speaker to the election commission, and then from there, where do you go? Anyway, so let's now come to the tension. The legislative party, in relation to a member of a house belonging to any political party, in accordance with the provisions of paragraph 2, or 4, means the group consisting of all the members of that house for the time being belonging to that political party, in accordance with the said provisions. Your Lordship sees the symbiotic relationship between the legislative party and the political party. The original political party, in relation to a member of a house, means the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2. Paragraph means paragraph in this schedule. Then 2, subject to the provisions of paragraphs 4 and 5, a member of a house belonging to any political party shall be disqualified from being a member of the house if he has voluntarily given up his membership of such political party, or if he votes or abstains from voting in such house contrary to any direction issued by the political party to which he belongs, or by any reason, or by any person or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So, what's important here to note is that he cannot vote contrary to any direction issued by the political party. So, obviously, in terms of paragraph P, it's the political party which issues the direction, not the legislative party. And the direction is issued through the leader of the political party, normally the whip, or the leader of the political party. Such person authorized. So therefore, the political party will authorize such person, and he is the whip. The whip term is not used in the 10th schedule, as you will notice. The term used is direction. Or by any person or authority authorized by this behalf, without obtaining in either case the prior permission of such political party. Normally, whose permission has to be obtained if I want to vote against the whip? Political parties. And political party is outside the house, not within the house. Within the house are only legislators. So you'll have to go to the whip. You'll have to go to the whip, or the person authorized, look, I want to vote against, or I want to make a speech against. I don't agree with this bill. And sometimes, actually whips do agree. It has happened so often with us. You say, no, these particular clauses, I don't allow me to speak, but I will vote for you ultimately because I don't want to violate the whip, but allow me to speak. And sometimes we are allowed. Then let's kindly come to the explanation. For the purposes of this subparagraph, an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. A nominated member of a house shall, where he is a member of any political party on the date of his nomination, as such member, be deemed to belong to such political party. In any other case, be deemed to belong to the political party of which he becomes, or as the case may be, first becomes a member before the expiry of 6 months from the date on which he takes his seat after complying with the requirements of 99, or as the case may be, Article 188. So a nominated member within 6 months actually can join a party, but not after 6 months. Then subsection 2 is very important. An elected member of a house who has been elected as such otherwise than as a candidate set up by any political party shall be disqualified for being a member of the house if he joins any political party after such election. I belong to that category, Malad. So, Malad, if I try and join any other party, Malad, I shall be disqualified.
Anglo-Indians.
That's right. That's for nomination, not
3.
Yes. 3 is a nominated member shall be disqualified being a member of the House if he joins any political party after 6 months. That's what I told your lordships. From the date on which he takes his seat after complying with the requirements of 99. Notwithstanding anything contained in the foregoing provisions of this paragraph, a person who, on the commencement of the Constitution, is a member of a House, whether elected or nominated as such, shall, where he is a member of a political party immediately before such commencement, be deemed for the purposes of subparagraph 1 of this paragraph to have been elected as a member of such House as a candidate set up by such party. In any other case, be deemed to be elected. This we don't really worry about. Para 3 is now deleted, Malad. Now, Malad, let's see what para 3 said. The lordships will find that in statutes, Malad. Statute item number 3. Let me just take it out.
Page 48, it's there. PDF 50.
Yes, PDF page 50.
50.
Yes. Worship has that?
Yes.
Yes.
Got it?
Hello, Justice Shah has it? Now, disqualification on account of defection not to apply in case of split, where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. And such group consists of not less than 1/3 of the members of such legislature party, he shall not be disqualified under subparagraph 1 of paragraph 2. So paragraph 3 as it then stood operated on the assumption that there is a split in the original political party. A split in the legislative party would not have been a defense, even if it is more than 1/3.
There has to be a split in the original political party.
Now, how does that split happen? Because he makes a claim. Before all this happens, demonstrates in the claim that a split has occurred, calls for a meeting of the original political party, has a faction, has a resolution passed, breaks away, Malaj, and then if he is 1/3, it's a defense. Even if he loses, Malaj, in capturing the party. He shall not be disqualified under paragraph 2 that he has voluntarily, sorry, Malaj, where was I? Yes, that such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 of para 2 on the ground that he has voluntarily given up his membership of the original political party, or that he has voted or abstained from voting in such house contrary to any direction issued by such party, or by any reason or authority authorized by it in that behalf, without obtaining the prior permission of such party, person or authority, and such voting or abstention has not been condoned by such party, person or authority within 15 days from the date of which such voting or abstention. And from the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of 2, and to be his original political party for the purposes of that paragraph. So the splinter group of that party can be a separate political party. He will, because he is 1/3 in the legislature, belong to that party, because that becomes his original political party. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, the 1/3 is in relation to the group representing the legislative party.
Yes, yes, I agree, Mother. Mother, that split may be minority, majority, it doesn't matter.
So long as, there is a split
There is a split.
in the original political party.
Correct, correct. So that's not the case here, Mother. On 21st of June, they were in Gujarat and they were in the Northeast, only the legislative members. And they never said there's a split. They said, we are the Shivsena. So that claim was also not there. Then came the 91st Amendment, Mother. 2003. Sorry, 2000. 1st January 2004. No. Yes. It's an act of 2003, but came into force on 1st January 2004. Then
Yes.
now, let's kindly see this constitutional amendment. They amended 164 of the Constitution, which you will find, Malas, in PDF page 52. In article, I'm sorry, Article 164 of the Constitution, after clause 1, the following clauses shall be inserted.
Where are we?
Well, is that PDF page 52?
PDF page 52, yes.
Well, this is the amendment starts, Mother, at PDF page 51. And the relevant part, because 1A and 1B were added. And if you see section 3 of that, in Article 164 of the Constitution, after clause 1, the following clauses shall be inserted, namely 1A, the total number of ministers, including Chief Minister and the Council of Ministers in the state, shall not exceed 15% of the total number of members of the Legislative Assembly of that state, provided that the number of ministers, including Chief Minister, shall not be less than 12. Provided further that the total, we are not concerned with that. 1B, Malas. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative council belonging to any political party who is disqualified for being a minister of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or where he contests any election to the Legislative Assembly of a state or either house of the legislature of a state having legislative council, as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. This also creates a lot of problems. That problem doesn't confront us in this case, because most of these people then resign, join the other party, get elected, become minister. So there is some some scope for challenge to this particular provision, its constitutionality. But be that as it may, we are concerned with the earlier part of this. That if you are disqualified, you can't be a minister. Now, your disqualification is pending. Matter is before the Constitution bench. Matter is before the Speaker, whichever it may be. And you are appointed by the governor.
And also there's a provision under the Representation of People's Act where they can't contest again.
That's right. Not for this, Malas. Not for the 10th schedule. That is for other disqualification, corrupt practice. There is no period here. That's why I say this is subject to challenge.
Right.
Okay.
There, Malas, if you were for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Now, Malas, what is happening in a ordinary case of a dharna on a road, a trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
We have already.
How many times do we give you justice? So, Malad, now, kindly now come. So, Malad, therefore, now, the bottom line is, there is no concept of a split anymore. Then the statement of objects and reasons for deletion of the paragraph at PGF page 54. This is para 2, Malad. The Committee on Electoral Reforms. Demands have been made from time to time in certain quarters for strengthening and amending the anti-defection law.
Where are you reading?
Malad, at PDF 54, the objects and reasons, Malad, of the deletion, Malad. Yes, yes. May I read that, Malad?
Yes.
Yes.
Demands have been made from time to time in certain quarters for strengthening and amending the anti-defection law as contained in the 10th schedule to the Constitution of India, on the ground that these provisions have not been able to achieve the desired goal of checking defections. The 10th schedule has also been criticized on the ground that it allows bulk defections while declaring individual defections as illegal. The provisions for exemption from disqualification in case of splits, as provided in paragraph 3 of the 10th schedule to the Constitution, has in particular come under severe criticism on account of its destabilizing effect on the government. Please see this, please mark this. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as the split is concerned in the legislative party. That is not necessary. Well, that's paragraph 2 there. The Committee on Electoral Reform, Dinesh Goswami Committee, in its report of May 1990, the Law Commission of India on 170th report on reform of electoral laws, 1999, and the National Commission to review the working of the Constitution, in its report of 31st March 2002, have inter alia recommended omission of said paragraph 3 of the 10th schedule to the Constitution pertaining to exemption from disqualification in case of splits. The NCRWC is also of the view that a defector should be penalized for his actions by debarring him from holding any public office as a minister or any other remunerative political post for at least a duration of the remaining term of the existing legislature or until the next fresh elections, whichever is earlier. It is proposed to accept these suggestions.
Mr. Sibal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No,
But that has to be resolved outside the legislative party. That cannot be still, according to you, resolved within the fold of the legislature party.
no, that question doesn't arise in this case because this,
No, I mean, we're not on this case, but that question as to who represents
that will happen outside the House.
that will happen outside the House. That cannot be resolved by the number of legislators within the House.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the House is actually given in a judgment of this court in Brahmanand Reddy.
That's
I'll
a
issue-
matter of the internal, the internal constitution.
That's right, that's right. You have to call a meeting, you have to raise the issues.
The
Manoj,
internal
for 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes, yes. That's right.
But the forum is.
You have to follow those bylaws, you have to call a meeting, you have to resolve that issue, and then you can do all this, Manoj, when paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections. Toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of a dispute that will arise and it will go to courts and the courts will decide in their own time. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there's a split in the political party, which is not even addressed, which is not even claimed. What is claimed is that we are the party. Now, we are the party can't be claimed within the legislative party. Well, that's for 2.5 years. I'm sorry.
For 2.5 years.
He was the minister. This very government never raised any issue. There is no public document saying that he is dissenting or he is a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House on 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do. The only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164 1B now gives you a way out. Instead of defecting, you can resign. And then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office, no governorship, no remunerative post.
Kind of cooling off,
I'm sorry?
cooling off of sorts.
Yes. Even in 361, Malaj, in fact, disqualification for appointment on remunerative political post. Capital B, Malaj. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment, Malaj, was very careful in trying to sort of settle part of the problem. But one thing was clear, they did not allow for bulk defections. Now, Malaj, paragraph 4, if I may read, Malaj, the 10th schedule. Oh, 1, Malaj. Just waiting for my lady, your ladyship. Okay. A member of a house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with another political party. And he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed by such merger. So, Maharaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he and any other members of original political party have become members of such other political party, that is, they merge into that party, or, as the case may be, of a new political party. Both of them may form a new political party formed by such merger.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes. No, but if he has not merged, he can form a separate. He will belong to the original. Supposing two parties merge and form a new party. Correct, Malaj? And he belongs to the original political party on which he won the election. He will continue to be the original political party.
I think Amar Singh sat like that.
Amar Singh, yes. He will continue with the original political party. That also issue is before the larger bench. So, if there's a new political party formed pursuant to merger, and I belong to the original political party on the basis of which I was elected, I continue to be in that original political party.
But clause 2 now again has
I'm coming to that.
requirement.
Yes, I've just
It
coming.
is 2/3 of the existing
Correct,
members of the
That's
legislature.
a very interesting provision, which of course doesn't call for interpretation now, but it has some nuances that's important for us to understand. And from the time of such merger, such other political party or new political party or group, as the case may be, shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2 and to be his original political party for the purposes of this subparagraph. So from the time of such merger, either to a party or to a new political party, he is deemed to be a member of that political party to which he belongs for the purposes of paragraph 1. So may belong to that original political party and is dissociated himself, or after merger he belongs to the other political party. No issue. Now comes the problem. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of a house shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Now, my lords, if 2/3 of the members don't agree, then there is no merger as far as the legislators are concerned. First, the merger takes place. Then the question arises whether you are 2/3 or not. If you are 2/3 and you agree, it is fine. It's a defense. If you are not 2/3, my lords, then you can be a separate group. So 2/3 happens to be a defense after the merger.
This deemed is also very important,
Yes.
because what 10th schedule does is that it doesn't create a new category. By saying deemed, it is relating back to the position of the assembly as it were
Yes.
when legislators got elected and come to the assembly.
Yes.
That position will be deemed instead
Yes.
of creating a new category.
Correct. For the purposes of 1, the merger of the original political party of a member of the House shall be deemed to have taken place only if not less than 2/3 of the members concerned have agreed to such merger. So 2/3 of the member, less than 2/3 of members, question defense doesn't arise. But if 2/3 of the members agree, then that's a defense. That's a perfect defense. So, Malas, looked at it from any standpoint, these 40 people have no defense under the 10th schedule. They don't claim that there's a merger. They say that they are majority in the legislative party. They claim that because of that majority, they can change the whip. They claim that they can change the leader of the House. They can call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. And so what happens, Malas, to the political party to which he belongs? What morality are we talking about? What conscience, Malas, conscientious objectors are we talking about? Conscientious defectors is the word that I used last time. And you don't raise a voice for 2.5 years. You are the leader. You enjoy the fruits of ministership. And suddenly you say that, look, now I am free to do what I want. I can join up with the BJP. I can go to Guwahati or wherever I want to go to, and that's it. So the question that your lordships will have to ask, Mullahs, how does the 10th schedule come to their aid at all? Under what provision of the 10th schedule can they have a defense? The schedule doesn't give them a defense. Whether it's a minority bulk moving away or a majority moving away. Which is when we last time were discussing this matter, this is what I mentioned. That the 10th schedule doesn't make a distinction between majority and minority. It just ensures that this habit of bulk defections, which is destroying the polity of this country, and by which elected governments can be overturned. So the objective is that you should not allow an elected government to be overturned. That's the fundamental premise on the basis of which paragraph 3 was deleted. You cannot destabilize government. And if you uphold such an act through a judicial process, you are enabling future defections and therefore destabilizing elected governments, which has far-reaching consequences for the polity of this country. That's the issue that your lordships have to decide.
Yes.
Well, it's paragraph 6 of the 10th schedule, but well, I'll take up the next topic tomorrow, well, if your lordships don't mind.
The transcription which we have made was from transcription is cleaned up in the early part of the evening. We'll give you a copy so that you can have a look at it if there's something, so
You can know what you argued.
Oh, I
don't-
that'd be wonderful.
Don't file an application for amendment.
No,
No. Thank you. I appreciate it. I hope you continue to be well. I'm sorry, but
Yeah,